Good morning, everybody, and welcome to this Breaking Bad Data Protection Practices information event. Just to go through some housekeeping, this session is being recorded, so if you have to drop off early or you have colleagues who might find it interesting, we will be making this available later. We will be taking questions at the end, so if you can use the question and answer facility to put your questions in there, and we will get to them at the end. If you have any particularly sensitive type of questions you want answered, but you don't want to be identified, we won't be publishing any details about who put in any of the questions or the actual question itself, so you can keep your confidentiality there. So without further ado, I will hand you over to Philippa.
Hi, everybody, and thank you so much for joining us. We're really looking forward to sharing our insights with you. Basically, what we did was we went through our requirements coming up for COVID-19 return to work, and we thought it would be fantastic to share some thoughts on them with you. So just a short introduction about myself. I am qualified in computer science and law. I've worked for about 20 years now in governance, risk and compliance across different sectors, moved to Ireland in 2017 with my family. And my focus now is basically purely data protection, privacy and cybersecurity from a compliance risk governance perspective. I primarily work as a consultant and provide data related solutions under privacy, and we provide auditing services under Cerity. And I'll hand you back to Liam now.
Thank you, Philippa, and yeah, great to be able to join you with you for this event. Just a quick kind of introduction then for myself. I have over 30 years working in IT. I started as a programmer way back in the 80s before moving into security infrastructure and networking in the 90s. I founded my own company, L2 Cybersecurity Solutions, in January 2016, and with the maxim of security simplified, in that the whole area of cybersecurity is kind of scary and technical, and data protection, GDPR stuff is all kind of boring and legal. So I try to put everything I do into plain and simple language that anybody can understand. So basically, I kind of similar to Philippa there, I provide cybersecurity and data protection, GDPR training and consulting. And also business continuity, IT disaster preparedness is another one of our offerings. So that's enough about me. So what we're going to cover off here today is duty of confidentiality, technologies, documentation. There's going to be a lot of documentation as a result of this from the return to work perspective. And then also we'll talk about the return to work safely protocol, and then we'll conclude our session, and hopefully we'll be finished before easily within the hour, so we can take plenty of your questions. So let's get cracking there, please.
Okay, so I think it's my turn now. We're just going to have to swap between the two of us, so bear with us as we do that. Basically, we wanted to start very quickly with the duty of confidentiality, because it doesn't quite fall under data protection. It's more general than that. And excuse us if you're in Ireland, we're not going to talk directly to our law or our government regulations or our government guidance, because there are people from other jurisdictions listening. So I'm going to bring it up a little bit and speak more broadly. Basically, if you consider the situation where you have an employee who is suspected of being ill, you probably we are to isolate that individual in the workplace, and there is some guidance given on isolation procedures and how to handle somebody who's suspected of being ill. So an employee is a little bit of a different situation to a member of the public. That really is going to have to be taken into consideration, because if you're sort of grabbing somebody by the arm and marching them down a hallway, or you have an isolation bubble in the middle of your cafeteria, other employees can see that. They can see that somebody is possibly infected with COVID. So it's a consideration now in the workplace that you deal with that in terms of guidelines for employees discussing the situation, possibly spreading rumors on social media, discussing it with other colleagues. Each have to deal with that in their own context. So please, when you're putting your isolation area together, possibly consider somewhere really out of the way, obviously easy to get to, but not in plain sight of everybody in the space where it's really obvious what's going on. Okay, let me go next here. Over to you, Liam.
Thanks, Philippa. So we've seen a lot of technology being offered around the whole COVID-19, and health screening and temperature screening is a really booming area at the moment. And while it is a very like this temperature screening is you're gathering lots of sensitive personal data on people because somebody's temperature is a piece of health information. So you've got to absolutely protect that data as strongly as possible, with really strong controls over who can access that data and what they can use it for. And I've been seeing some thermal imaging technology. Philippa shared something with me yesterday, and I had to look through this YouTube video. And there's this camera that does it. It scans you. If your temperature is abnormal, it'll flash a light. It'll issue an audio warning. It will send an email with the video of the person to various people. It'll push a notification to people's to their phones. So this is a lot of health information is just now flying around in seemingly an uncontrolled fashion. Like I would not consider email to be the most secure manner for transmitting health information. So I certainly wouldn't be emailing videos of people's temperature checking around the place. And also, as Philippa had mentioned there about the showing some discretion about somebody who is potentially has a fever. You don't want an audio warning or flashing lights, alerting everybody in the vicinity to, the person being possibly infected. So with that, there's also some tracking technology which can be used, again, using video cameras, that they can track an individual going through an area like a supermarket or a shopping mall, things like that. That sort of tracking technology is also quite invasive, and these things really do need to have before they're installed, they need to have a data protection impact assessment carried out, and we'll cover that off in a bit more detail later. But you can't just go ahead and just put this stuff in place without some really careful consideration about the data protection aspects about it. And finally, I've also become aware of a number of particularly sporting organizations. They've been to help with social distancing, implementing online booking facilities on their websites to to enable people to book slots so that they won't be banging into other people in the corridors or in the changing rooms. So that's great, but the websites themselves, in some cases, they may not have a certificate on the site, ensuring that any data that is any personal data that people type in on this website to book their slots is going across the internet in a secure fashion. So you need to make sure that your websites are secure before you use them for taking these bookings. So that's what you need to consider when we're talking about the technology. Back to you,
yeah, Liam. Yeah, thanks. If I can add to that just very quickly, with that camera that I sent you the video of, it's not just sort of taking a picture of a temperature, kind of a red outline. Some of them take an actual photograph or actual video of the person involved. So it's clearly identifiable. It's not merely just a temperature that's being recorded. So it's really invasive in my opinion. Okay, so we're onto documentation now. Just bear with me as I share the screen here. Again, I have the return to work documentation, the return to work guidelines, the safety protocol. I think it will share the tabs there. Yeah, it looks like it's doing what it should. Okay, so we have government issued guidelines here, which you must read if you haven't read them already. It's the return to work safety protocol, and then I've got the NSAI guidelines that add some more detail there. So they're quite comprehensive. However, there are places in them where it's not entirely clear what the direct instruction is. So if you're not sure, you or your committee that you set up under this should go and seek absolute, certainty on what you should be doing. Let me get here again, sorry. Here, getting back to work, you've got to have your response plan, etc., etc. And then the documentation that we're particularly concerned with, and I will say this, I was personally quite disappointed to see that there was no mention of data protection really considerations inside here, because there's a lot of data gathering, a lot of information gathering that's required. So before your workers return to work, you are required to have a form that has these points on. So it's page 13 of 29 in the guidelines. Do you have symptoms of cough, fever, high temperature, etc.? Have you been diagnosed? Are you a close contact? Have you been advised to self-isolate? Have you been advised to cocoon? So that's a piece of information that you have to keep, and I won't use this document to carry on, and the NSAI guidelines are much more visual and probably better to discuss with. There's the visitors questionnaire that you need to have. Okay, so if you have a look at this, you're capturing a lot of information on members of the public, strangers to your business outside of the framework of employee-employer relations. Okay, so that's one piece of documentation there. You're required to zone your work area. So here you're tracking movement between areas, and you're basically keeping a log, and that's where Liam was talking about the technologies that can track through buildings. If you think about having to manually manage this type of operation, right, it's going to be quite onerous. So people are going to turn quite fast to technology to do it for them, especially in the larger workplaces. So please be aware of your obligations in terms of confidentiality over data, how you're going to store it. We'll go through all of those in a little while. Obviously, cleaning records have to be kept, and then there's obligations on communications, and there's flows, and there's loads of contact between different parties. So it would really have been quite great to have some data protection guidelines put into here. Anyway, go and have a look at these documents. It's the return to work safety protocol and the NSAI guidelines for workplace protection guidelines. I'm going to switch back to our slides now. Yeah, Liam?
Just real quick there, the NSAI guidelines are linked to in the return to work safety protocol document. So you need to get one, and then you'll get the other.
Okay, excellent. Thanks for that, Liam. Okay, so you've got this requirement of documentation, and as I said when we started, we've got people from different jurisdictions here. So your guidelines might require you to keep different sets of documentation. You've got to decide, are you going to keep the documentation in paper form? Are you going to keep it in electronic form? Are the systems that you're using, like your HR systems or maybe security modules, whatever, do they have add-ons available now to keep the COVID documentation? You're going to have to decide, what's the most expedient way for you to keep your documentation that you're required to keep. We'll go through the specific data protection concerns here and now in terms of retention, data sharing, etc., and so on. Okay, here's the next slide. Here has a pre-return to work form. As an example, thanks, Liam mocked that up for us. So you might have this with employee name, employee ID number, and the questions that you have to keep. So you can see how sensitive that information is and how highly personal it is to somebody. And we've got to bear in mind that whenever we do these assessments and considerations in terms of data protection, we've got to keep the data subject at the fore. And we've got to bear in mind also that the employee is considered to be a vulnerable data subject. It's part of a vulnerable group of data subjects where you know, if you're looking to process data based on consent, there's imbalance of power, etc., etc. So always keep your employee, your data subject at the fore when you're putting these documentations together and the procedures, processes around them. Okay, the one thing that I would like to raise here again is the close contacts list. So you're not only keeping data on your primary data subject, you're keeping data, you're processing data on third parties. So you're going to have to consider that too. I'll hand over to you now, Liam. Oh, sorry, it's me again. Yeah, me in a few times in a row there. Okay, so lawfulness of processing, we're getting right into the difficult part now. Lawfulness of processing requires us to identify a legal basis for data processing. So we're processing health-related data, which is considered special categories of data. So we're basically going to have to identify an Article 6 legal basis for processing and an Article 9 legal basis for processing under the GDPR. I know there are some South African attendees listening, so you know, look at the Protection of Personal Information Act and decide on your bases there. And for the rest of you, you're going to have to identify appropriate basis. I am not going to say you're processing data under this basis or that basis. Okay, so this is not a recommendation from me, but what I would like to share with you is the kind of assessment you're going to have to make if you're processing based on a legal obligation. So this is our absurdity where we do the audits. And just to give you an idea, so say I say now, okay, the government's telling me that I have to process data related to COVID. I have to keep these questionnaires. So I'm processing based on a legal obligation. I have to be able to answer all of these questions. Is the legal obligation, is that the most appropriate lawful basis? Is consent more appropriate? Maybe. Is contract more appropriate? Maybe. Is public interest more appropriate? Maybe. I've got to go through this assessment and see. And the other point I'd like to highlight here is that, is the processing necessary? Okay. So in consideration of keeping tabs on temperature, is the processing necessary? So say we're using the back to work guidelines. Does it specifically say that I have to measure the temperatures of employees every single day, several times a day, whenever they come into the space? Okay, and is the processing, so say I'm using my thermal imaging, whatever technology, cameras, you know, scans, whatever, is that processing essential for me to comply with my legal obligation? So if we bring it up and say our legal obligation is health and safety in the workplace, is that essential for me to comply with the legal obligation? And is my way of processing a reasonable and proportionate way of achieving compliance? So am I going over the top with the technology that I'm using, or is it reasonable and proportionate? And everybody's circumstances will be different. Okay, so it's not a one size fits all here. You're going to have to make that assessment for yourselves, and you're going to have to document it. So basically that's the Article 6 basis, and then the Article 9 basis for the special categories of data you're going to have to identify there for your context. Every processing activity is going to have to be documented with a legal basis and a further legal basis if necessary. So if you think about it, your processing activities will be your documentation, all the different documentation you're keeping is processing, you know, contact with third parties, contact with the HSC, contact with the GP, those are all processing activities. Processing activities might be monitoring your zones, processing activities might be, I don't know, Liam, help me out here with some ideas for people so they understand like what they're going to have to document.
Yeah, like, so you've got, you know, are you processing, like most of these guidelines, by the way, are focusing on employers monitoring their staff. It's not the members of the public. That's totally, you know, going after the members of the public.
That's like the Wild West at the moment.
Yeah, you don't want to be doing temperature scanning on members of the public.
People are, Liam. People are. So if it's a public venue, then some people are. So you're going to have to identify if you are one of those parties that is taking data and processing data on members of the public. You are going to have to actually justify the lawfulness of that processing.
Yeah, exactly, and that's what I think we're covering coming up next.
Okay, there we go.
Under the data, under the articles 13 and 14, which is basically the right to be informed, so that you know, under the GDPR, if you're processing somebody's personal data, you have to be open and transparent about everything you're doing with their personal data. So you're going to tell them who you are, where you are, how they can contact you, what data you're gathering, what's your legal basis for gathering it, how long are you going to store it for, how are you going to dispose of it, who's got access to it, who do you share it with. There's all this sort of information that you need to be able to provide to these people. So this not only includes your staff, as we say, that's what mainly the return to work safety protocol is all about, but if you do happen to be scanning members of the public in your premises or on your site, then you've got to provide this type of level of information and make it publicly available so that people can get access to it. And similarly, very important is the retention period for some of this data. Some people might want to hold on to it for months, years. I don't know how long, but I would think you don't really want to hold on to it for that long. After all, one of the principles of the GDPR is that you only hold on to data for as long as is necessary for the process of processing it. So if it's known that keeping the health data for, if somebody gets infected, it takes 14 days, you might want to hold on to that data for maybe 21 days or 30 days, but no more than that. You really don't want to be holding on to health data for too long a period, because the longer you hold on to it, that means the more data you have and the more data you have to protect. And with health data, it's sensitive personal data. You have to protect it really, really stringently. So that's where you have to be. So being open and honest, and telling people how long you're going to hold on to it for. And then, of course, we have the next one is the right of access. If we can tip on to the next one there, please. So the individuals have a right to gain access to their personal data, and they can make a request. They can come in to your office or premises and say, I'd like to know what personal data you have on me, and I want to get a copy of that data. So you need to be ready to be able to address those issues. You have, once a request has been made and it's a verified request, that you have, ensured it's the correct individual, and you've set out the scope for the request, that you then have to provide them with a copy of the personal data that they have requested within 30 days. And you cannot charge for providing that service. So be aware of that they can come and get that data from you. And you have to set this out as well, notifying them about their right to be able to make this request. That has to be set out in the right to be informed information that I talked about previously. So be ready for, and by the way, the data subject access requests are one of the biggest areas of contention for people in the country. In the last 2 years, the Data Protection Commission, their annual report, has outlined that there's been, 30% of the complaints made to them have been around failures in respect to data subject access requests. So that 30%, that's the biggest percentage of all complaints. So, you need to get your access requests correct. And then we're talking about recipients. So, there's going to be lots of people that may need to gain access to this data. Do you have to share the information with, the HSE, doctors, other data processors or vendors, or cloud providers? There's lots of these people are going to end up getting this data. So you need to be, absolutely certain that, we have, we need to be certain about the uses that they're going to put to that data. Like we had the example there last week where the HSE provided an employer with the test results of mass testing of their employees. They provided it to the employer before they provided it to the employees, which apparently was based on some 1981 law that the HSE relied upon, which, my book, that doesn't matter. They really were breaching the individual's rights there, because the individuals should have received that data before the employer. It really was unacceptable, that carry on. But you've got to be certain that, what are these other recipients going to do with any data you're providing to them. And particularly if you're using any kind of technology that might be sharing the information in the cloud, what are those cloud providers going to do with that data? Perhaps have you got, are you using an app to capture some of the, instead of having the paper forms that we talked about earlier, maybe you've got an app for that. Loads of people are doing apps these days. So, who has got access to that data? What are they going to use it for? Are they going to use it for any other purposes than what you've agreed? So you've got to protect yourselves there and just make sure that the, only the appropriate people have gain access to the data, because health data is really, really, really sensitive. So I think that's back to you then, Philippa.
Thanks, Liam. Yeah, we just had a question come in here. If you're in a shared enterprise center, which there are a couple around the country, would it be the responsibility of the center, or each tenant, would each company need their own equipment and data collection? So that's a nice context to carry on talking here, where we're talking about data sharing and responsibilities. So basically what Liam's saying there is that the guidelines state that you would have to share information with some people. So the HSE is obviously requiring some information sharing, and then the guidelines, if you read through them, are saying contact the GP. And they're not entirely clear as to whether, like, an employer sits down an employee and says, phone your GP in front of me, or whether the employer is mandated to phone the GP. So that's where we're saying, look at the agreements. Okay, so if you look at all the parties that are getting data, or if you're looking at an example like this, a shared space, an enterprise center, or a building where you might have, a reception area that's managed by a management company, and then you've got your own space in there, you're going to have to sit down with your committee under the guidelines and say, how are we going to handle this? Okay, you've got space sharing considerations, you've got facility sharing considerations. You've got to agree on the technology you're going to use. You're going to have to assess the vendors of that technology. You're going to have to assess the access to the technology or the records. Who has access? Again, the retention periods. You're going to have to assess your guidelines for data subject rights requests. Liam refers to them as access requests. You're going to have to assess your how you're going to handle data breaches, because all of you are probably going to be equally responsible for that in these some of these scenarios. And then you're going to have to assess your how can I say, your roles. So are you a separate data controller to the HSE? Yes. Okay, that one kind of goes without saying. If you're in the building scenario where you have an office in a shared space, or you're a separate data controller to the overall management company, how are you going to construct these agreements? Who is going to be responsible for what? Who is going to be the lead? Who is going to be the final say? You need to put all of that down in agreements with clear responsibilities and obligations. So Article 28 kind of governs data processing agreements. Some of these will be data processing agreements. Some of these will be data sharing agreements. Some of them might be, a new type of agreement that basically outlines the roles and responsibilities, but not necessarily a data processing agreement. On the point specifically of data processing agreements and the technology that's available, the tracking technologies and the, the temperature measuring technologies, you need to assess your data processing agreements with those vendors. And I will highlight this to you. Please look for any kind of data kind of sharing or any terms in those agreements that say that the vendor may use the data for other purposes. So keep your eyes open there. Okay, so here we have the documentation. Data protection requirements under Article 30. Yeah, okay. Article 30 is my current hobby horse, if we can call it that, where I firmly believe it's probably the most misunderstood article in the GDPR. Your requirements for keeping records of processing activity under Article 30, they extend basically to every single organization, where the exemption for keeping these ROPA, as we call them, is very small. So if you're doing regular data processing and if you're doing processing on health-related data, basically, you would have to keep records of processing activities. Very technical format, so go look at Article 30 of the GDPR for that format. and you're going to have to make sure that each processing activity, we gave you a couple of examples before, each processing activity is logged. The lawful basis is logged, recipients are logged, transfers out of the EA are logged, etc., etc. I won't go into great detail here. I've got a webinar in 2 weeks' time with Claude if you want to log on there to find out more about this. So if we're looking at simply the communications, let's think of all the different types of communication activities you have under these guidelines. Communications with close contacts, communications with the GP, communications with the HSE, communications with the data subject themselves. If you're dealing with members of the public and you're processing data, this gets quite interesting. If you're logging health status, that's another processing activity. If you're keeping an ongoing health log of an employee, that's a processing activity. If you're tracking movements in the building, that's a processing activity. Each of these needs a line in your ROPA, so you're going to do quite a bit of sitting down and documenting here. I would recommend that you do training for your staff representatives, your committees, and make sure that they understand that there's obligations, data protection obligations together with the health and safety obligations, and that you examine your retention periods very, very closely. So Liam already mentioned retention under Article 13 requirements. You're required, if you don't know the exact retention periods of your data, you're required to notify the data subjects on how you're going to determine those retention periods. So if we're looking at retention policies for data, like think of all this data now that you're collecting purely for COVID, first, we're going to look at the law and say, is there something in law that requires us to keep this for a certain amount of time? So you might contact the HSE and say, how long do we need to keep these records for? Because the HSE might have specified guidelines there. So then we look at if there's any kind of requirements under, say, insurance contracts. You might have insurance policies related to the workplace. Your insurance company might require you to keep documentation. That's another aspect you're going to have to consider. Then we look to see if there's any contracts involved in the retention periods there. So with your technology specifically, if you're implementing, say, the thermal imagery cameras, you're going to have to look at those contracts to see if that cloud data is stored for any length of time, and you're going to have to include that in your retention policies. So yeah, please go look at Article 30 of the GDPR and determine what your obligations are in that regard and keep the documentation.
Thanks, Philippa. So back to security aspects under Article 32. We talk about technical and organizational measures to secure the processing of the personal data. You got to make sure, again, as I said, that you have all the appropriate measures put in place to, protect health data. Any kind of sensitive personal data must be protected as strongly as possible. It will have, if it's stored electronically, you're going to have it encrypted. If you're storing it on paper form, then it's got to be locked away in filing cabinets with only relevant personnel who will have access. You're going to need to dispose of it when the retention period is up. You're going to have to make sure you dispose of it appropriately. So that could be certified shredding for paper-based data. You also want to make sure you apply appropriate backups to any electronic data to make sure you protect that in case it does become corrupted or somebody gets hit with a ransomware or something. You've got to make sure you have backups that you can return the data to its proper form again. You also, if you're bringing in new technologies as a result of the COVID-19 and the return to work safely protocol, you're going to need to make sure you update your policies, and particularly your information security policy, to reflect the new use of the technology that you're implementing here. So then we talk about data breaches, one of my favorite topics. You've got to make sure you're ready for to be able to handle a data breach. So you should have a data breach handling procedure, because if you don't have one and you suddenly have a breach, you're going to not be prepared, and you're probably going to maybe run around and panic and not handle the situation appropriately. So if you have a data breach handling procedure, then you just simply, breach has happened, consult the procedure and follow it through. Don't run away from it. Don't try to put your head in the sand. You've got to be able to just follow it through, keeping the appropriate documentation. And one of the greatest parts of a data breach handling procedure, I find, is always the last one, which is the kind of the review after the fact, once things have settled down. You should always be, it's very, very important that you should always carry out a review of the situation that happened, so that you can see, what went wrong and what can we do to improve the situation in the future. You should always be learning. You should always be learning from any mistakes that you make. So you make sure you have that data breach handling procedure. And then we also then is required under Article 35, there is a data protection impact assessment. I mentioned this earlier when I talked about implementing these thermal imaging cameras. Because you're bringing in new technology to your operation, and in particular that it's processing sensitive personal data, or special category of personal data as it's officially called, but because of that, you need to carry out a data protection impact assessment before you implement the solution. And the data protection impact assessment will basically take you through finding out what are the risks that this technology might bring to the personal data of the individuals that you're processing or recording. What risks are there to their data, and what mitigations could be put in place to help mitigate those risks, so that that you could potentially put in place the technology. But you have to carry this out. It has to be done in a very subjective manner. Objective manner. You have to be, look at this thing fairly and, with a cold view to see, is this technology appropriate? Are we processing data in a secure manner? Are we protecting the rights and freedoms of the individuals by using this technology? So it's really important that you do this before you put this stuff in place, not after, because if it's done after, it's kind of too late. I think you had...
Yeah, I wanted to hop in there, Liam, because people kind of, their eyes glaze over as soon as you say data protection impact assessment. If you have a complaint from an employee or a member of the public because you've implemented these technologies, or if you're not keeping records correctly, the first port of call is going to be, where is your data protection impact assessment? If you have an inspection or an inquiry from the commission or your supervisory authority, where's your data protection impact assessment? Because you should have logged everything that you know about this technology or procedure, if it is a procedure you're putting into place that's kind of new and processing data in ways that haven't been processed before. You that DPIA will kind of be used as the guideline for determining kind of how prepared you were, how much attention you paid to the protection of this fundamental right. So you need to make sure it's absolutely correct and absolutely thorough. And as Liam said, absolutely objective. It kind of also is subjective, because you need to always have your data subject at the core of the assessment. So when you're looking at putting in technology where the members of the public might be involved and employees might be involved, you're going to separate that into two separate parties and do your assessments for each one separately, I'd say. One very important part of the DPIA, and that's receiving far more attention than it has before, is the stakeholder engagement part. So you're required to do some sort of stakeholder engagement on your data processing activities. So that means you have to sit people down and devise, some kind of way of getting their opinion, on what you're about to do, and you need to consider their opinion and thoughts on the matter. And we find that stakeholder engagement can be very illuminating, when we're looking at risks to the data subject, because stakeholders, especially if they're data subjects, might actually see things in a different light to, your security professionals or IT people. They might throw up things that you've never considered, and you should consider that as part of the risks and mitigation. Last point on this from me is that if you find that there are risks that cannot be mitigated, to say you're making use of a technology, basically, and please, this is not any kind of political statement from me, but a lot of this technology comes from China, right? So you have this technology and it might default to, I can see Liam's laughing there, this type of technology might default to like a cloud service that might be based in China. You need to be aware of that, and I can tell you now, if you put that DPI in front of me and said that the technology is backing up data to a cloud service, you know, and the data is going out to China, I'd be saying to you, please stop that right now. Do not use it. Do not use it at all, because there's no way that you can justify using that kind of tech or service. So be very aware of those points in your DPIA. Okay. On that point, I am next here on transfers out of the EEA, so vendor risk assessments. Again, we've said it several times before, so I'll keep it short and sweet. Look at every single vendor, every single third party, every single recipient of data involved in each data processing activity, and make sure that you're identifying where that data is going. So is it staying inside the EEA? Is it transferring out? Where is it going to? If it's transferring out, what basis is it transferring out on? Is it under an adequacy decision? So very short list of countries there: New Zealand, Canada for commercial, Israel. There's only about 9 or 10, I think. I haven't checked the list very recently. Are there binding corporate rules in place that you can transfer out in, et cetera, et cetera? So that's quite a technical consideration here. Article 44 onwards in the GDPR will give you some guidance, but make sure you examine those data flows and see where that data is going. Over to you, Liam.
Thanks, Philippa. So just in conclusion, you know, we're not just here wanting to preach to the choir. We want to be able to help, and I'm offering a free 1-hour confidential online consultation to help any small business owner to assess their needs. So if you want to take advantage of that, just send an email there to info@l2cybersecurity.com. and we can schedule something.
I'm just going to quickly chuck through these slides to give a short overview, if you don't mind. So just a summary. Sure. If anybody lagged on a bit late, we discussed the duty of confidentiality. So when you're preparing your isolation areas in the workplace, make sure that they are private and that you have policies and procedures covering, you know, employee privacy, basically. So everybody in your workplace should know that if somebody's identified as possibly being ill, that is a private matter and not to be spoken about, if that's where you're going to go with that. We covered technologies. So thermal imaging technology is really bursting out now. Make sure you assess it correctly. Tracking technology, so movement of people inside buildings between zones. You might have tracking technology as an overlay on like your CCTV technology, and website security. So as Liam said, if you're going to use websites to collect information, make sure that you've got your SSL certs, TLS certs, and whatever else it is, you know, in place and correct. Okay, here we've got documentation. So make sure your documentation is nice and clean. I don't know why the slide's not advancing there. Sorry, let me just force it through again. Okay, here we go. Documentation, your documentation for the return to work and the return to work guidelines, all the different forms you have to keep. So visitors forms, return to work forms for employees, your staff movements between zones. That's all the documentation under our guidelines. There's quite a bit more. That's not only it. So please go and read carefully and make sure you're collecting everything you need to collect. Other jurisdictions might have different documentation they're mandated to keep. Okay, here we have spoken about the documentation. Particularly of particular importance here is the close contact list. So the third-party data you're keeping, just mind that very carefully. Data protection requirements, you're going to have to identify the legal basis under which you process. So look at your Article 6 basis and then Article 9 basis for special categories of data. Liam spoke about transparency requirements. So this is your data protection notice or privacy notice, as some people know it as. Okay, so Article 13, just go and read it. It's like a checklist of what you should include. Article 14 is for those third parties. I'll highlight that. You're processing third-party data within 30 days of receiving that data. Basically, you're going to have to inform those parties of the fact that you're processing the data, where you got it from, and they're going to have to know who has it and what they're doing with it. So just make sure you're tight on that. Liam spoke about data subject access requests. Go and have a look at Article 15. And to highlight there, the basis that you've chosen, which we spoke about previously, so if you're processing under a legal obligation, affects the rights that are available to the data subject. So the data subject needs to be informed in that data protection notice under Article 13 of what rights they enjoy, dependent on the legal basis that the data is being processed under. Liam spoke about recipients of data vendors, data processors, data sharing. There's a lot of data flying about between people. Just be aware of that. The big point here is that the HSC was releasing test results to employers. It doesn't look like that's permitted anymore. And please keep an eye on the Data Protection Commission website, because they'll probably be updating us a little bit more on that point. Okay. I spoke about the types of documentation agreements that need to govern this data sharing, especially if you're in shared workspaces. Who's doing what, who's in charge of what, so make sure that you understand the obligations, you know, what your role is in all of this. Oh gosh, there, sorry, I'm losing my place here now. Okay, and then the data protection requirements under Article 30, records of processing activity, please make sure that you keep those because they are like a Bible for what you're doing. They're really fantastic and keep you on track. So as much as they might be a pain now, they will stand you in good stead later, because if you get an access request, you also know exactly what's going on, who to speak to, where to find that information. If you've got a data breach, they will direct you in that regard too. So make sure you capture all your processing activities for this data processing under the COVID guidelines, and do it in the format as prescribed under Article 30. With your retention periods, you're going to have to determine those too, depending on what the law requires, etc. Liam spoke about security, so you got your technical and organizational measures. So that's basically the technology that you're going to use to protect the data. Organizational measures would be policies, procedures, training, etc., like who has access to what data, kind of falls between the two. Make sure you update your information security policy to reflect any new technology in use. Okay, be prepared for a data breach, guys. This is going to be a reality soon, that this data is just sitting in stores all over the place, and it's quite a juicy part of data to access. Okay. And then we've got DPIAs. I won't go into detail there again, but please make sure your data protection impact assessments, do them properly. Consider the stakeholder engagement, and make sure that if you cannot mitigate the risk, then you should not be doing that activity. If you get to the point where you really have to use the technology and you can't mitigate the risk, then there are guidelines for approaching the Data Protection Commission to basically see where to go next from there, or getting permission to carry on with the processing activity. These data protection impact assessments take time. So if you're planning on going back to work anytime soon, opening up your buildings, etc., start on them now. Okay, and then obviously examine every single piece of technology you're using to see where your data is going. Is it outside of the EEA? You're going to have a basis for that. Okay, so I think that's us, Liam.
Yeah, that's it. Just put up the final slide there, just for people if they want to
Okay, I shall do
keep
that.
in touch with us on any of the various social media platforms. We appear to be all over them all, so you know that information is there if anybody just wants to take a screen grab of that, if you want to contact us, or as I said earlier, if you want to book a slot with me, just send an email to info@l2cybersecurity.com. So, do we have questions in the Q&A?
I've answered a couple here, Liam. I don't know if you want to maybe talk a bit more on some of them.
Okay. So we have, this is a guideline. Does it mean there is a legal obligation to implement these? So yeah, you thought your answer was yes. If you look at the legal obligation guidelines on the ICO site, particularly, you'll see it is in scope. Simply, the government is requiring you to do so. You are mandated in terms of employees, but for the public, members of the public, yeah, no, you have to figure out what your legal obligation is there. Yeah, if nothing else to answer there. we had the Enterprise Center, which you did discuss. Are there good solutions you can recommend to store these activities, or Excel is getting too complicated? Yeah, we have our good friend Claude has a fantastic solution, which I know you're a firm fanatic about it.
Yeah, I am definitely.
I have to sit down and review it sometime with him.
Yeah, I just say very briefly there, Liam. Claude has a background as a business analyst, amongst other things. I'm on with him in 2 weeks' time, but he has just an amazing intrinsic understanding of how data should be stored. So where we might get ourselves wound up in circles trying to log data and activities and so forth in Excel spreadsheets, his approach to it is incredibly simple, where you capture once and it's used in different ways to produce the kind of records and reporting that you need under the GDPR. So I'd highly recommend chatting to Claude about using the solution. As I said there, it's modularized, so depending on what you need in your business, you can sort of pick and choose the modules that you need to add in. It's also fantastic for making sure that you capture training records correctly, and in light of the questionnaires we've been looking at today, the return to work type of questionnaires, there is a questionnaire module in Bisonio that can be accessed securely. So through portals, you could serve that questionnaire to your employees or visitors and keep it securely, because it's an incredibly secure architecture behind the scenes.
Yeah, and I think, if somebody wants the kind of complete package for doing data, GDPR, their organization, if using Bisonio and Cerity to do the audit, you'd be in really great shape if you use both of those platforms. I just see another question or a comment came in there about the ICO being a UK.
Yeah, I'm busy answering that.
So it's, yes, they are UK, but yeah, exactly. It's they still adhering to the GDPR for the moment, and their website is a damn sight better than the Data Protection Commission's website for finding information on it. Now, it will probably diverge as Brexit goes on.
In the next couple of months, I'd say.
Yeah. So once that divergence happens, then yeah, the UK ICO site wouldn't be a good reference site to use.
Yeah, it would not be my first reference.
Yeah. The Data Protection Commission website is improving. They're putting a lot of good information up there nowadays, so it is worthwhile. But there's also, if you wanted to, for example, do a DPIA. Now, if you look at the Data Protection Commission's website, they have a big wordy document, which I think most people would lose the will to live when they look at it. But if you look at the French data protection site, CNIL.fr, they have an English version of the site, so you don't have to the French, but if you don't speak it. But they have a free tool called PIA, which is a kind of again, it's in English, but you can use that to carry out a data protection impact assessment. It'll kind of walk you through and gather all the data you need for the DPIA.
Yeah, the ICO has a word template for DPIAs, Liam, but I found it to be the only time I'll use that is if the client is in the UK, because it's kind of become known. So people expect the DPIA in that format, but I find it doesn't prompt you, in the ways that it should prompt you, the way that the PIA tool does. And I'll say this also, and I'm sure Claude won't mind me saying it, but we're working on a DPIA module for Bisonio, which should be quite interesting.
Okay.
Yeah.
That's great. Yeah. Excellent. I definitely need to sit and talk to him. So.
Yeah, definitely. Okay, I think I don't think there are any more questions coming in. You're going to save this on YouTube, right?
Yeah, we're going to stick it up on the big old Google's video.
Okay.
And when we'll get that up to, either today
I should
or tomorrow.
get it to you. Yeah, it should be up. I can get it to you by this evening. So guys, if you have anybody in mind that you think might benefit from listening to this, then please, by all means, let them know about it.
Yeah, we'll be putting putting a link out to it on all of our socials there. So if you're following us on those, you'll get to hear when it comes live.
Okay, thanks so much for joining us. Thanks, Liam. That was fantastic.
Yeah. Thank you, everybody, and stay safe out there. Wash your hands, and let's get through this together.
Yeah. Yeah. See you soon. Okay. Bye.
Bye. Bye.